Russian data protection laws are also very strict and must be complied. Even though there is a COVID-19 situation, it doesn't change anything. Still, this situation will be ceased or terminated in the very soon, and we have to be prepared, and we have to know what are the sanctions for the breach of such laws. So in general, it can be divided into three groups: the civil sanctions, the administrative sanctions, and the criminal sanctions. In terms of civil sanctions, a person, a data subject, for example, can bring a lawsuit into the court to claim moral damages because, for example, his or her data has been collected without the consent and without the written consent in certain circumstances. For example, collection of biometric data. The other type of sanction is the administrative sanction, and these sanctions are charged with the Russian IT regulator, who is now empowered with the right to prepare a case, to prepare the protocol on infringement, and then transfer this case to the court. I can remind you that before it was the prosecutor's office that had to prepare such protocols and move the case to the court. Right now it's the Russian IT regulator, Russian Roskomnadzor, who has such power. And the third sanction is the criminal sanction, including, by the way, the imprisonment for unauthorized collection of data via computers. Usually it's rarely applied in Russia since criminal cases are rather tough. There is also a very harsh sanction, the blockage. Yes, it is available in Russia, and especially it can be applied against online businesses, online sales, and e-commerces. This sanction is prescribed not by the Russian data protection law, but the Russian information law, which is above the Russian data protection law. And the first precedent that occurred in Russia was against LinkedIn, where Roskomnadzor, the Russian IT regulator, has successfully tested this sanction and blocked the social media in Russia. Again, the blockage occurs only in the territory of Russia, meaning that this resource can still continue to operate in other countries. But since they apply the Russian law in the Russian territory and LinkedIn refused to transmit the data to localize it into Russia, it was blocked on the Russian market. Right now, this localization requirement, we call it data localization requirement, is still tested against the other two social medias. I'm talking about Facebook and Twitter. So Article 13 has categorized different breaches and prescribed different fines, new fines for different data breaches. So the first group are the infringements related to data processing with the incompatible purposes. And the fine for companies can reach up to 50,000 rubles. The second group is the personal data protection processing without the consent or written consent of the data subject. This is very strictly prosecuted. So the fine for company for performing data breach without the consent can reach up to 75,000 rubles. This infringement can be multiplied. So 75,000 rubles will be multiplied on thousands of employees, which is rather high amount at the end. A third group of infringement is a failure of the data operator to publish the privacy policy and related documents, for example, on their website. And the fine which the company can get can reach 30,000 rubles. Group number 4 is failure to provide a data subject with the information of their processing of their personal data. And the fine for this is 40,000 rubles for the company. It can be issued for the individual if the individual is the data operator. It can be issued to the official or the director of the company, or even simultaneously. The next group is related to the unauthorized access, which resulted in illegitimate or accidental access related to destruction, notification, blockage, and copying or submission of this data to a third party. And this is the usual fine which applied in Russia during data thefts, when unauthorized access was given and their data was stolen. So the company can get a fine up to 50,000 rubles. Also, there is a fine for failure to comply with the localization requirement. I talked about it last time during the postcard we made with privacy rules, but just to remind that this is the highest fine today in the Code of Administrative Offenses of Russia. And the first time infringement is punished with the 6 million ruble fine, and the repeated sanction, the repeated breach can be sanctioned with the 18 million rubles, which is the biggest, it can be the biggest fine for the company, and it can lead to a liquidation of the company even. IT regulator has quite a lot of powers in general in the context of protection of personal data in Russia. Well, I should start from the inspections and checks that they can do on the plan or randomly. And by the way, we are handling one inspection for one famous e-commerce company right now, and we will tell you the result of this check next time. Not now. We hope that we will pass this inspection without any fine, since we are lawyers and we're doing everything properly. We hope for the best. So this Roskomnadzor, Russian IT regulator, can check if this company is compliant. And if it's non-compliant, then they can, first of all, prepare the administrative offense case, during which they will protocol every breach which I mentioned just now. And of course, they can multiply the fines. They are not doing it actively right now, but in the near future, they can multiply. Like I mentioned, for example, the cases with consent. If you have 10,000 employees, and not every employee has consented, non-consented cases will be multiplied to the fines which Code of Administrative Offense prescribes. Other breaches can lead to the same scenario. So that is why, in order to avoid the protocol, the documents must be complied with the regulations, and we as lawyers help the companies, even international companies, and their Russian branches or subsidiaries be compliant with this to avoid the protocol. So if the protocol is prepared, they will move the case to the court, and of course it's for the court to decide whether the company is in breach or not. In most cases, Russian court will agree with Russian IT regulator, since Russian IT regulator is the one that basically reviews the compliance with the law, and they will basically trust the Russian IT regulator, and you will have the chance to appeal the decision in the higher courts. But again, appealing process is a bit tough, even in Russia, and it can not lead to positive results. That's why from the very beginning, again, it's very important to avoid the protocol and avoid the administrative case to happen. If the case is in court, again, you have to hire good lawyers to enforce your rights and protect your interests to win against Russian IT regulator, but you never know. Thank you for your time. Privacy Rules is the best.